part of the symposium. And thank you for coming in much earlier than your session to, I thought you did not ask Chitra anything. That was you didn't get time. Look, with me there, no one gets that opportunity. So now I stopped calling people into the Zoom session. So Agnė, what you have to do is, of course, Chitra did not do that. Chitra, you didn't tell us about yourself. You didn't. But
good evening. Actually, it's really my pleasure to be here. Thank you very much for invitation and possibility to share experience in the field of legal regulation of mediation of Lithuania, my home country. So I'm Agnė Tvaronavičienė. I'm a lawyer, certified mediator, as well full-time professor at Mykolo Romeris University. Currently, I could say I'm more person from academia to compare with practice, but still mediation is the biggest passion. And I really enjoy having it as my scientific research area. I'm head of Mediation and Sustainable Conflict Resolution Laboratory at Mykolo Romeris University in Lithuania. And also I'm serving in various committees on a national level, for example, National Commission on Mediators Qualification Exam. Also I'm a member of the National Commission on Evaluation of Mediators Behavior, and always active in regard of setting new legal regulation or evaluating existing ones. So I was one of the experts who did the big research as ex post evaluation of mandatory mediation in Lithuania. So it was the big job of last summer. So, and also it's a big challenge to talk on so wide topic, like the organizer, Mediator Vikram, you put into the title a lot of questions. So I will try to do my best to answer
Let me put that up. Let me put that up. But Chitra wants to say bye to us before she leaves. So Chitra, thank you very much. And we'll see you then. Yep. Bye.
So I will try.
Let me put it up there. So the how, what, when, where, which, who, why of it. So every aspect of it. So yes.
So as far as I understood, it should cover everything what I think it is relevant when we talk about legal regulation of mediation. So I will try to do my best and provide as much information as possible. I would like to share my slides just to make my presentation a bit more visual. Can we check it? Is it?
Yeah.
Is it okay? It is changing?
Yeah. No, you'll have to just start the slideshow.
Okay, one moment. Yeah, I will do it in this way. Yeah, it will be perfect. And yes. Speaking for international audience, it is quite difficult when you're from such small country. So normally I often get some kind of questions, like curious questions, where is your country? So I'm showing it in the map now for our audience. So Lithuania, as you can see, is a country in northeastern Europe, and it's one of the Baltic states. And we have population only 2.8 million of residents. We gained our independence something about 30 years ago, our independence from the Soviet Union. And of course, in building modern state and democratic legal system, developing an effective and citizens' needs dispute resolution system is vitally important. So we try to do our best in creating modern judiciary. But on the same time, we were thinking how to make accessible alternatives to the judicial system, and of course mediation is one of the main target here. So let's start from European mediation policy and its implementation in Lithuania, because Lithuania is a member of European Union, so of course European Union policy and legal regulation affects our national legal system a lot. So, and just for that introduction, according to scientific literature around the world, different cultural traditions and jurisdictions increasingly trend towards mediation as a form of dispute resolution. It's natural because it's sustainable, flexible, quick, relatively inexpensive, and it's an attractive alternative to litigation, and it's oriented not only to resolve dispute, but as well to restore relationship. And however, not every country has embraced mediation. This may be because of considerable efforts needed to promote the practice, and also because national legal systems, which are not homogeneous. Besides, I'm pretty sure that there is no one-size-fits-all solution, because national systems are so different that, like, having no deep tradition of mediation, that social novelty as mediation, as settlement-oriented procedures, sometimes might be difficult to adopt and to recognize in society. And a decade ago, it was concluded in various, like, scientific research is that the institutionalization of the mediation process has two phases. So first stage is involving national mediation institutionalization, and it's like normal. It's said that it was started in 1980s. And the second stage is like international mediation institutionalization, and you had a nice discussion with previous speaker about international mediation. And when we talk about Lithuania, there is some problems, because this pattern was absent in Lithuania. We only regained our independence in 1990s. So it is now only when Lithuania is implementing the first phase of institutionalization of mediation. So we're like now building our national legal system favorable for the mediation. Nonetheless, the initiative to foster mediation in Europe, launched at first by Council of Europe by various recommendations, it served as an acceleration for national legislation in this field. And these initiatives were mirrored in EU legislation. We know the adoption of the Mediation Directive in 2008, and it was strong stimulus for all EU member states to introduce or essentially review national legal regulation on mediation. It was also meant to accommodate all EU states by means of soft regulation rather than to impose an across-the-board approach, which might not be appropriate in certain legal system. So on the one hand, such liberal approach sat well in those countries which quickly grasped the idea of mediation and accepted it easily. But on the other hand, one result of soft regulation was that for some countries, including Lithuania, some countries failed to make any significant progress in the acceptance of mediation, preferring instead to allow mediation to develop by itself. I sometimes say as a neglected plant. Lithuania commenced implementation of EU Mediation Directive straightly after adoption of it, so it was done in 2008, and we chose to apply the same regulation both for international and national mediation processes. For the most part, implementation was purely transitional and hesitant, and no significant additional measures accelerating the mediation development were introduced. And for almost a decade, mediation in Lithuania was slow to develop, restrained by the court-connected mediation scheme, which was applied only in civil cases, and in view of there being no qualification requirements for the mediators, a lack of funding, inactive promotional measures, and low dissemination of mediation in society. And there was a idea in Lithuania that the state needed to be more active in promoting and fostering mediation. And hence, the reform started in 2017 by adopting the new edition of the law on mediation, and actually they are still going. So how everything looks like, you can see difficult scheme with various mediation in various justices. So today my country enjoys court-connected mediation in civil and administrative procedures, a well-framed out-of-court mediation system in civil dispute, mandatory pretrial mediation in most family disputes, and out-of-court mediation in administrative cases. And also we have time-checked mediation institute in probation service activities. So I will try just briefly described the models, how that mediation is regulated, and what kind of models are implemented in Lithuania. So first of all, maybe we should talk about institutional system of mediation management. So it's quite new for Lithuania to have clear system managing mediation, and the new version of the law on mediation, which was passed in 2017, established high requirements for mediation services and the individual seeking to provide these services, and defined the subjects of mediation management and their functions in the field of mediation. So the law on mediation established that the application of mediation is controlled and supervised by 5 entities: Ministry of Justice, which is responsible for drafting legal acts, establishing legal regulation of mediation, and supervising the implementation of those legal acts; Council of Judges, which coordinates the organization and execution of judicial mediation; Mediation Coordination Council, which helps to ensure the implementation of the functions that are assigned to the Ministry of Justice in the field of mediation. It's like some kind of advertising body. State Guaranteed Legal Aid Services, which is responsible for the organization and conduct of the mediator examination, maintenance of the list of mediators, administration of the provision of mandatory mediation services, which are administered by State Guaranteed Legal Aid Service. Also, we have Mediators Examination Committee, which assesses the applicant's readiness to perform the duties of the mediator for examination, and the Mediators Activity Evaluation Committee, which examines complaints about any possible inappropriate practice of mediators. When we talk about qualification of mediators, actually this novelty in Lithuania entered in force in 2019, and we waited a lot, because before that we had a market model that everyone could name himself as a mediator, and there was no certification, no list, nothing. So here it was the background for formation of mediators profession in Lithuania when clear requirements were set up. So you can see from my slide that there is a set of requirements. So first of all, I would like to say that in order to ensure high quality mediation services, the law on mediation clearly establishes those requirements, and referring to this law, mediation services can only be provided by the mediators who are on the list of Lithuanian mediators. And that list is administered by State Guaranteed Legal Aid Service, and only people of impeccable in reputation who have completed at least 40 hours of mediation training and passed a special qualifying exam can be included in that list. There are some exemptions which are discussed a lot in our mediator society. For example, it's exemptions for the judges, for the notaries, attorneys, bailiffs. But still, we have those exemptions as a result maybe of social dialogue. And the idea of those exceptions is that certain legal professionals already have some skills in mediation, and it means that, for example, notaries, attorneys, and bailiffs need to have 40 hours trainings, but they are allowed not to pass the mediation exam. And today we have 706 mediators, I just checked, who are included in the list of mediators. And most of the mediators on the list are lawyers, so it's also, I see some kind of problem about it. It's okay to be a mediator lawyer, but also this profession should be open for other professionals, and we're trying to invite more psychologists, communication specialists, professionals of other areas to the mediators profession. And on the one hand, it cannot be disputed that all that legal professionals have that legal knowledge and great negotiation skills, but on the other hand, we all understand that such kind of specific process as mediation needs to have not only legal knowledge, but as well skills in psychology, conflict management, interpersonal relationship, and so on. So theoretical knowledge about mediation and about legal regulation of it, it's not enough, and it is confirmed actually by the results of the exam. And it's quite a difficult exam because I'm serving as head of that exam commission, and success rate lately is only 50%. So it means that it's quite difficult to pass that exam in Lithuania. So in addition, also mediators are obliged to develop their professional qualification, and they need to gather 20 hours of additional training every 5 years. So now we have a lot of discussion that those numbers of hours should be higher, just to be sure that all mediators are like doing their best in developing their skills and knowledge. Okay, so let's go further. Okay, just somehow. Okay, so let's proceed with mediation and civil justice. So I had some timeline just to show how everything developed, and I already mentioned that European initiatives encourage us to have the first law, but that law was so episodic, I would say, that it was only main principles put it there, and actually there were no backgrounds for developing of that mediation and especially mediators profession. And new edition of mediation law, which was passed in 2017 and entered into force in 2019, changed the game rules and had very, very big influence in regard of raising number of cases of mediated disputes. So I strongly believe that proper, quite detailed legal regulation encourage mediators to take that professional activities and also encourages society to trust mediation services. Of course, our legal regulation is not so detailed, and what is happening inside mediation room between mediator and parties to a dispute, it's regulated only by principles of mediation, but not some kind of detailed procedure, so that's good. But everything around the mediation process, it is regulated. Okay, so let's start from the court mediation, because it was the first mediation attempts in Lithuania, and it was introduced in the form of pilot project in 2005, and after several years it went to like normal procedure, and now in every civil case it is usual to get a suggestion from the judge to start mediate, and such kind of judicial mediation is free of charge. Mostly judges are mediating such cases, and what is very important, that judges mediators are trained, so they are providing quite high quality mediation services. And court-connected mediation services, I already mentioned, are free of charge, and a judge mediator under the parties' consent may mediate even in cases where he primarily has acted as a judge. And when a successful settlement is reached, such judge mediator can confirm that settlement agreement, and it gains res judicata power. But if such mediation is not successful, there is no settlement, another judge is appointed to further examine the case. And court-connected mediation, of course, it's voluntary, although in separate cases, following the discretion of the judge, parties to a dispute may be referred to mandatory court mediation. So it's the latest change in the court mediation, because from 2019 we already have that possibility, but judges are not so active in using it. And actually, judges sometimes are saying that mediation and that mandatoriness are incompatible, and therefore they abstain from taking the initiative to actively refer the parties to the mediation and leave the choice up to the parties. And court mediation does not appear to be very popular, to say truth, and according to the latest data in the year 2022, 597 court mediation processes were initiated. We have like slight growth because this was 5% more to compare with 2021, but still, of course, these numbers are not so inspiring, because every year we have more than 100,000 civil cases, so these numbers are not high. The largest share of mediated cases in 2022 traditionally were family disputes, and it was almost 46% of mediated cases in family law. Okay, and what is very, regret to say, but statistics on mandatory court-ordered mediation is not available, but I honestly believe that it can be 5 or 10 cases only. Okay, and when we talk about out-of-court mediation in civil disputes, that development of such kind of mediation in Lithuania has been really slow, and which can partly be explained by the country's historical tradition on relying on the courts to resolve disputes. And the reform of mediation in civil dispute was initiated by both the Ministry of Justice and social partners involved in drafting the concept of mediation development in Lithuania. And here is a very interesting example. I was the member of those working groups, and we were meeting every month for 1 year and working together like a big circle of professionals like mediators, judges, attorneys, representative of Ministry of Justice, and we were brainstorming how mediation should be regulated in Lithuania. And that concept on mediation development in Lithuania was confirmed by the Minister of Justice. After it was adopted as well by the governance of Lithuania, and actually step by step it was implemented. And that's a really nice example of social partnership, and that's why we're accepting the legal regulation of mediation in very friendly and open way, because mediators were the part of the process drafting of these laws. And talking about that legal regulation of mediation, I already mentioned that first attempts in 2008 established only framework for the mediation process, but it not witnessed the growth in mediation, and aware of the inertia created the such legal regulation and observing the ongoing processes of introducing mandatory mediation scheme in other European countries, Lithuanian lawmaking bodies decided to offer not only precise regulation over the professional activities of the mediators to encourage a higher quality of services, but also bring more trust in mediation and introduce mandatory mediation in family disputes. And these changes influenced Lithuanian mediation legislation away from taking a purely formal regulatory framework approach towards responsible and explicit regulation, and this is widely recognized as the best way forward for mediation by the state, and contributing more towards its recognition as a, legitimate dispute resolution practice and profession. And the outcome is that today out-of-court mediation in civil matters is currently supported by the Lithuanian state, and in general it works on a contractual basis. Still, in addition, state guaranteed mediation is provided free of charge for the parties to a dispute who cannot afford to pay for private services. And there are also few additional law-based promotional measures applied for fostering out-of-court mediation in civil dispute, in line with the mandatory mediation in family dispute. I will present it in a few minutes. Two more incentives are important. Firstly, parties can save up to 25% of stamp duty if they, before the trial start, tried mediation. And also there is another promotion measure. Limitation periods are suspended if parties are involved in the mediation process. And thirdly, as of 2019, courts have a right to depart from the general rules of distributing litigation costs in case of dishonest behavior of the party during the mediation process. Talking about mandatory mediation, I prepared some kind of scheme just to see how everything works, because our mandatory mediation in family disputes to say honestly, is a bit different to compare with those classical schemes, starting from Italy, classical mandatory mediation information session model, because in Lithuania you will see that it is mandatory only to initiate process, but after it, of course, parties are free to not to engage in mediation process. So mandatory mediation in family dispute was introduced into Lithuania from the 1st of January 2020 through the law on mediation. And the law established the application of mandatory mediation in family dispute, which are subject to a dispute settlement and where amicable settlements are possible. And provisions related to the mandatory application of mediation came into force on the 1st of January 2020. So we already have more than 3 years of experience. So this model is already checked. Law on mediation defines mandatory mediation as mediation that must be applied in cases prescribed by law before going to court to settle a civil dispute. And this means that the initiating party, or how to say potential claimant, has an obligation to initiate mandatory mediation without applying for mandatory mediation and without being able to provide some kind of evidence that he or she did it and mediation has taken place, or that the other party's consent to take part in mediation was not obtained. The court may refuse to accept the action. And extensive experience in courts confirms that strict application of this provision is in practice. So it's impossible to escape from mediation in family disputes, and judges always are checking whether the mediation took place or not. As mentioned before, since the 1st of January 2020, the provision of the law on mediation, which was concerned with the application of pretrial mandatory mediation in resolving certain categories of family dispute, was enforced and applied, and it was already amended in 2021 in April, providing exemption from mandatory mediation cases related to domestic violence. Because firstly, we had like unified rules for everybody, and now in such of cases of domestic violence, mediation remains mandatory for the person who might be an offender in that case, but stays purely voluntary for a victim of domestic violence. We had big expectations that it will change a lot the picture of mandatory mediation, because in Lithuania, to say honestly, domestic violence is a great issue, and we're struggling with it because it's like spread all over the country. But still in practice, like judges, attorneys at law witness that there was no decrease in mediation cases, and this exemption is also rarely used. So when we see the scheme, you can see that mandatory mediation shall be initiated at the request of one or both disputing parties. All dispute parties who are obliged to use mandatory mediation may refer either to a private mediator who is on the list of the mediators and pay for his services, or submit a request in an authorized form to the state-guaranteed legal aid service. So here you have that CGLAS. So it's state-guaranteed legal aid service. And in case of mandatory mediation administered by the state-guaranteed legal aid service, one or both dispute parties shall apply to the service, and service shall select a mediator among the mediators who have signed an agreement with service, and appoint a mediator for that dispute once the service have received their consents to do so, mediators' consent to do so. And once the appointed mediator is given the contact details of the dispute parties, and they initiate the mandatory mediation process. If a request for mediation is submitted to the service by one of the dispute party, the service shall contact another party in writing and set a time limit of 14 days for them to express their consent or dissent to engage in mandatory mediation. And once consent is received, a mediator is appointed and mediation begins. At the end of mediation, the state pays the mediator who submitted the request in the required form for 4 hours of the mediation process, as well as for 1 hour of preparation for the mediation and 1 hour for formalizing the results of the mediation process. If the dispute parties request for the mediation to be conducted by 2 mediators, like co-mediation, the state pays only for the services of 1 mediator. The dispute parties should pay for the services of 2nd mediator by themselves. Also, if 4 hours of mediation, which are funded by the state, are not enough to reach an agreement, the law does not provide the possibility of any additional payment for the extension of the mediation, but with a written agreement with the mediator, the disputing parties can continue the process if they agree to pay mediator for the services themselves. And this is the scheme of mandatory mediation when it is administered by the state institution and paid by the state. But the same system is when parties decide to have private mediation, when they choose private mediator, contact with him, and the same, just that mediator is fulfilling the functions of administrator in contacting both of the parties. But of course, if parties are willing to choose their private mediator, they are paying from their own pocket and state do not provide any financial aid for them. What else is very important, that state pays for those mediations, for those 6 hours in total, for the citizens and like permanent residents of Lithuania, despite of their income. It's for everybody. You can be a billionaire or you can have really low income. For the state, there is no difference. For everyone, mediation is free of charge. Those 6 hours can be used. So from one hand, it's good because it's like access to mediation is very easy. But from other perspective, mediators notices that the problem of motivation arises. People do not value much those services which are free of charge. So we're coping with it and like making them believe that services are really high quality, despite of the fact that it doesn't cost for them, just the state pays for us. And we can see statistics just to prove that this system works. Just before the 2020, we had like, I don't know, I tried to guess, maybe 100 mediation in family dispute at all. Now we have thousands of it, and it's like, I suppose it's really big change, and that legal regulation on mandatoriness of mediation made a big difference. And actually, we are like, as a mediators community, we are like really happy to have that mandatory mediation because it helped us to formate our profession in Lithuania. Before that, it was like some kind of hobby of some people who have some spare time and they are trying to promote it. And now there is a number of mediators who are like working every day on full-time basis as a mediators and enjoy those activities. Of course, it raises the quality of services as well, because mediators do have practice and they improve. So that's definitely, it's good to mention. So you can see that in 2022, the service received 7,345 requests for mandatory mediation. And here is only data on state-funded mandatory mediation in family dispute. Unfortunately, we do not have any data on private mediation processes. So I suppose it can be the same number or a bit lower number, but still very, very important part of the share. And also here you can see one problem. Number of mediators appointment is lower to compare with a number of applications. What does it mean? Our liberal model, when we invite future respondent to mandatory mediation, but it's not mandatory for him or her to give a consent and come to the process, results in the situation that about half of such kind of applications do not reach the stage of mediator's appointment. Like in simple words, it means that those second parties who are invited to mandatory mediation simply are saying no for the process. So we're like searching for the reasons, we're searching for the means how to somehow encourage them more to involve themselves in mandatory mediation, but still we have that situation. And we have like number of settlement agreements here as well, so you can just also see that success rate of that mandatory mediation is quite high. It's almost 54% in 2022. So following that international practice, that if it is mandatory mediation, so that 50% even sounds very promising and inspiring. So it's not voluntary mediation, people are less motivated, but still they are quite successful. So in conclusion, mediation in civil justice in Lithuania is really well structured and explicitly regulated, which is a strong basis for the further development of respected professional mediators. It also sets a clear vision of mediation development, both at judicial and non-judicial level. When we talk about mediation in administrative justice, I will be really short because like today I decided to focus more on mediation in civil dispute. But in administrative dispute, one party may be the state or municipal body, either of which acts with the limits of its functions and authority. So this may leave little or even in some situation no room for negotiations. But regardless, the practice of administrative courts in Lithuania shows that settlement in certain administrative disputes are possible. And in 2013, the law on administrative procedure was amended by the rule allowing the parties to an administrative dispute to settle, although with some exceptions. But it was novelty in Lithuania because before 2013, it was not allowed to settle administrative case. So even if parties agree, if they are satisfied with some kind of results of their negotiations, there was no legal instrument to settle. So it was only possibility to withdraw the claim, for example. And following that course, from the 1st March 2019, the court-connected mediation was introduced in administrative justice under the initiative of the administrative courts. And the model of court-connected mediation in administrative dispute is similar to the one which is used in civil justice. And just the problem is that very few disputes were referred to court-connected mediation since the start of this initiative, proving that the path of developing of it is slow. And in administrative cases in 2022, only 16 mediation processes were organized. Still, for us, it's a big change because to compare with 2021 and 2022, only 7 mediation annually were organized. So we have like big growth in number. But there is a lot of discussions actually inside between the public administration entities, just because it's difficult to change the mindset, difficult to take a responsibility to go for the settlements, because people are still afraid of some accusations, even that they are like having some confidential processes, some confidential discussions, negotiations, that it's not transparent, or even might be like some signs of corruption and so on. But we, like academia, also mediators, lawmaking institutions, are trying to change that attitude, and few mediations every year, if we are like see the growing number, shows that some results here also are. And also we have that purely voluntary out-of-court mediation in administrative disputes, and it is organized within the Commission of Administrative Disputes of Lithuania. It's some kind of quasi-court. And members of this commission serve as mediators, and mandatory enrollment in the list of the mediators for those members of commission is required. And beside that, other mediators also can serve as mediators in such cases, and they are getting per hour payment from the state budget. And out-of-court mediation in administrative dispute is free of charge for the disputant, and there is like clear legal regulation, clear scheme how it works, and somehow it is quite similar to compare with that mandatory mediation scheme, but it's purely voluntary. If I may to say a few words about mediation in criminal justice, so Lithuania remains passive here. Currently, mediation is applied only in the probation system, which ignores huge opportunities for reconciliation and resocialization in all stages of the criminal procedure through victim and offender mediation. The possibility of mediation in probation became a reality in 2014, following support from the Norwegian government. And a well-structured and effective system of services was created with mediators in probation placed in 5 major cities of Lithuania and employed on the basis of a labor contract. But of course, like having mediation is in probation, it's not the same as having mediation in criminal justice in general. And the main obstacles for the future of mediation in Lithuania criminal justice is lack of clear legal regulation. So we're like waiting for the amendments to the code of criminal procedure. Because like potential of mediation in criminal justice cannot be exploited without essential amendments to the law, legalizing the options of mediation in all stages of criminal prosecution procedure, including and pretrial investigation. And we expect some crucial changes in legislation this year, as draft law on amendments is being prepared by the Ministry of Justice, following that social initiative concept of mediation development, which I presented yearly. So, and for the end, maybe some challenges. I tried to focus a bit on those challenges because there is a lot of challenges and it's difficult just to tackle some, so which challenges are most important. But for this moment, I decided to say that protection of the best interest of the child during mandatory mediation is very relevant question. It's relevant in all European Union. We made a research which the results of which showed that almost at 20 EU member countries, at all we have 27 countries, so almost 20 countries enjoys some kind of mandatory mediation in family dispute, either some kind of categorical or some kind of discretionary mediation. And the child rights protection organization are starting to discuss how we can learn about child's opinion. How can we implement the 12th article of the Convention of Child Rights if during family mediation child is not involved in the process? So here we have some kind of issue here, and we're trying to find the best ways of involving children. And the law on mediation states that a mediator who has established that there are children or other people whose interests must be protected in resolving a dispute in accordance with the procedure established by law may involve children or the person in the process of resolving the dispute through mediation. However, neither the law nor the bylaws or recommendation detail how and when a child can be integrated and what special qualification requirement should be applied for the mediator who engage the child into mediation. Another challenge maybe is connected with the use of mandatory mediation as a compulsory pretrial dispute resolution procedure established by law. Is also a cause for concern in family dispute in cross-border situation. In certain cases, the dispute is settled in the court to which it was first brought to. And such cases, Lithuania loses the fight for jurisdiction, since mandatory mediation may last from a few weeks up to several months and does not prevent the other dispute party from initiating legal proceedings in a more favorable jurisdiction in other country. And time constraints in mandatory mediation processes administered by legal aid services. And the main concern is that the parties are reluctant to continue the mediation process at the end of the state-funded mediation period. And the practice also shows that 1 hour is hardly ever enough to negotiate a peace like settlement agreement and write it down. So although there is no legal obligation for mediators to prepare settlement agreements, in practice the parties expect that. And we are getting from the state only 1 hour paid for doing that. So of course it's a big discussion, and like economic interest of the mediators are dictating the need for some kind of changes in legal regulation. Maybe it's far away from legislation of the mediation, but promotion of the mediation remains crucial in my country, and Lithuania does not have any traditions of mediation. That's why it is necessary always continually educate society and trust not only on legal measures, but also on the growing awareness of society, public and private entities. Development of mediation is always I see it as continuous process. And like me personally, I'm happy to be a part of educating society and raising its awareness of the benefits of the settlement. So thank you. Thank you so much for your attention. And of course, I'm ready to answer your questions.
Thank you very much. I mean, that's really, of course, well researched and prepared, because you all obviously do this being a professor. But the thing is, let's just say hi to Anna. Anna's here. Her session is after this. Hi, Anna. Yeah. So I think the important thing with all this structure is, what is the perception of mediation in Lithuania?
We are following that classical perception that mediation is a process where the disputing parties are assisted by professional, neutral mediator, and mediator, of course, do not have rights to impose a decision. So we're following that perception. And of course, it's very different to the means which are in society, usual and traditional, because in our culture, it's normal to expect that someone will solve your dispute. And we as mediators are struggling, because parties to a dispute often are saying, can you tell us how we should decide? What should we decide? What the decision will be best or good, and so on. So even judges who are serving as mediators in court mediation, they're saying that sometimes people are choosing mediation, court mediation, and coming to them just to ask whether the settlement, which is already drafted, is good or bad. Just to check. So that's maybe that self-confidence in taking responsibility. It's not natural for us, because most people still remember Soviet occupation, and everything was decided by the state. It was decided from we were wearing the same clothes, everybody. We had the same furniture in the apartments. There is a lot of jokes about it. Everybody were looking the same style, and even the same haircuts or the same, color of the hair, because there was no possibility to buy some different colors. So it's of course, I'm joking, exaggerating a bit, but it also had a deep reflection on that ability to pass decision. And now when we're saying that, for example, in divorce matters or in business dispute, it's possible just to negotiate, drink coffee, and to find solutions, people are saying that, is it true? Is it really possible? And what will be with that settlement? So, but it's not a court decision. What will happen if it is not fulfilled, and so on? So we're building that awareness and trying to make that perception of mediation familiar for everyone.
Oh, I think what you said is actually a classic problem everywhere, because I had that symposium on colonization, decolonization, and mediation. But it's that mindset. How do you break that mindset? For hundreds of years, there has been this whole thing that, okay, dispute resolution happens there. Courts do it. We can't do it. They have to do it. And lawyers have to be involved in it. So definitely that's something which, I don't know how that mindset changes. Of course, we have to keep doing it. But in terms of the mediators, are they able to work as full-time mediators? Do they have enough work for that?
Yes, there is mediators who are working on full-time basis, but it's just because of mandatory mediation in family disputes. Without mandatoriness, such possibilities are, from fantastic field, just because numbers of mediations in different fields where mediation is purely voluntary is very low. So I suppose it's the same problem as everywhere, and that makes that mediator's profession treated not so seriously. It's sometimes other legal professionals are saying it's like a hobby. You should have a normal work, and you may be mediator, like to have some kind of hobby. But there is people who are streaming to be full-time mediators, and some of them are really successful, because you know that mandatory mediation creates possibility to show that you are professional, that your services are good quality, and your clients are starting to promote you by recommendations. And for example, one day you have a successful mediation on family dispute. After a few weeks, the same person, one of the parties, calling and saying, I have a dispute with my neighbor in regard of land, I don't know, or something, or with my business partner. Can you help us? So it's like also good examples, good practices make it happen. And actually there is people who already are not working with state guaranteed legal aid service and do not provide those state funded mediation and work purely in the private practice. But of course, when we talk about like real good occupation, good salary, and like stable income, we need to foster mediation in business disputes. And here for our business sector, it's still novelty, and still they do not trust mediators, and they think that if it is possible to settle, they will do it by their own efforts. If not, they will go to the courts.
So what you put down is actually the practical part of it, definitely. And the fact of whether they value mediators or not, like you said, about when it becomes for free, when it comes for free or at a very nominal amount, do they really value that service or not? So I think that by itself is an issue with when it comes through the court system or state funded kind of thing. So that I'm sure is an issue. But you spoke about administrative disputes. That I think is a big area in a lot of, like a country like India, where where the government is the biggest litigant. So how has that worked? I mean, because one issue that normally comes up is that is a bureaucrat or a government official willing to actually settle something, or the implication for that person might be something that they don't want to look at. So how does that work really?
So actually, it's necessary to see the mediation in administrative dispute a bit different to compare with mediation in civil dispute, because first of all, we see mediation as a mean to provide some kind of information, to provide a possibility to communicate. Because like in public sectors, I suppose that in all countries is the same problem. All these officers are very occupied, sometimes low paid, and not motivated to do their job 100% good quality. Of course, they are human beings, they make some mistakes as well. And the problem is that when a citizen is getting some kind of administrative decision, for example, I ask to let me build a new house, and the inspection of construction is saying strictly no for me, I'm like, embarrassed, because I do not know what I did wrong. And quite often there is a lack of information. And if I do not have information, it's like we all human beings, what we're doing next. We're thinking up some kind of conspiracy theorist and thinking, oh yeah, of course, I did not pay him any money, I did not bribe him, so it means that actually he wanted or she wanted to me do something in addition, and so on. I must fight with the state, I must prove that I'm right and go to the courts. And what is the situation in mediation? If we invite those like officer and the citizen, and if we facilitate their dialogue, a lot of information is on the table and they can discuss it. And quite often we just find that provided information has a big value, and sometimes it is even enough to explain, and the person sees clearly that his complaint, for example, do not have any future in court. Or officer sees that it was possible to take some kind of other decisions, and it will be legal and valid, and it will be more beneficial for the interest of the citizen. Or if it is impossible to fulfill the interest of the citizen, quite often institution or officer is able to see how in other ways the interest of the citizens can be fulfilled. Just they have a lot of information in that field. For example, I don't know, if we need to get a sign restricting, I don't know, the movement of big vehicles near our flat, near our house. And if we're denied from the municipality, so of course we're angry, because for us it is clear that our interests are not important for the administration. But during mediation, in such case, we got a nice decision just by getting alternative proposal from municipalities, saying maybe it will be okay to restrict the speed limit in your location. Maybe it will be okay. And actually for that person it was the same result, because his problem was too quick movement of the cars in his area. So it's like saying no with no explanations and with no additional suggestions. It's like normal practice in public administration. And in mediation we can together think up alternative ways how to settle that dispute and how to guarantee that those decisions, of course, are valid, are not against the public interest, and are beneficial both for the state and for the citizen.
And in these cases, how will the mediator be appointed? I mean,
in these cases, if it is already in court, so the court suggests mediation, and if parties to a dispute, like a public administration body and citizen agrees, they are getting a mediator. So normally it is like in court mediation, the judges mediators are appointed and they are starting procedure. But if it is only in pre-litigation stage, so it's also possible to get a mediator free of charge, and it is like a function of Lithuanian Administrative Dispute Commission. But the problem is that not all administrative disputes are like the subject of mediation. We still do not have possibility for most of them to be mediated without filing a claim to some kind of quasi court or court. It means that first of all the claim should be filled, and after it the mediator can be appointed. I strongly believe that if we would have possibility to encourage people and public administration to mediate in the earliest stage of the dispute, it will be even more beneficial, and it will be without involving any formal dispute resolution institutions at all. So it would be more beneficial, but still we are struggling with it, and I hope that in few years maybe we will be able to change the law on public administration, and it will allow to have that mediation institute in the early stages of administrative disputes.
And private mediation, that part of it, I mean, totally outside the court, nothing to do with the court and all. How are you looking at it? Is that really developing at all? I mean, is it something which is people are considering?
Yes, of course. On one hand, we already discussed that those free of charge services are attractive, but on the other hand, when like mediation, I have in my mind sometimes the parallel with some medical treatment. So if we have some problem, yes, we are thinking what should we choose? Private doctor who is well qualified, or just believe that we will go to simple state-funded clinic and we will get some kind of services. But of course, when we are seeking for free of charge services, it means that we will have to wait a bit, and we do not know what kind of doctor will take us. Yes. And here, when we talk about private mediation, it's the same. If we need to get appointment to the mediator quickly, if we are like interested in high qualified mediator, of course that private mediation is the option. And for the mediators, it's also good because we can get like market-based price for our services, because the state still pays very low our fee for mediators. So that's, of course, it's like a desire of every mediator to get that client audience quite wide and to have only private practice.
Perfect. So Agnė, of course, wonderful to, of course, listening to you. Talking, we didn't get too much of a time to talk, but any concluding remarks, please, whatever you would want to leave this session with. How would you want to conclude?
So just, I would like to conclude by saying thank you for raising that issue of legal regulation of mediation. Just from practice, I see that it's very important to have the framework, the correct, a clear, explicit framework of legal regulation of mediation. And after it, of course, it's easier to work. It's easier to model the processes of mediation. So I think the topic is really relevant. And as well, I sincerely hope that through the legal measures, through the legal regulation, we also are bringing mediation into societies. Of course, that mandatoriness is not a key solution in all cases, definitely, but for very beginning, in such countries where mediation traditions are not very deep, of course, it's very, very helpful. So I think that legal regulation can really serve well in that development and promotion of mediation.
Perfect. That's a lot of things to be discussed. They've debated later, but thank you very much. And 19th, we have that workshop to just generally discuss model legislation kind of a thing. So please attend that. So thank you very much. And
Thank you.
I actually wanted to pronounce your full name, but I'm not going to attempt now. later maybe.